I am going to pick up where the court left off, and that is at count 4, assault in the second degree intentional, Connecticut General Statute, section 53A, 68(2). The state charges the defendant at count 4 with assault in the second degree, charging that in the county of Fairfield in the city of Shelton on or about the 14th day of May, 2022, at or near 43 Laurel Glen Drive in said city, the defendant, with intent to cause physical injury to one face on teal, did cause physical injury to the said face on teal with a dangerous instrument, to wit, a knife, in violation of section 53A 68(2) of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows: a person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. We'll refer to the court's previous instruction on specific intent at 15. Physical injury is defined as an impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious, it may be minor. Element 2, caused physical injury. Second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. We refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Faison Teal was injured as a result of the actions of the defendant. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to that person or some other person. Element 3, with a dangerous instrument. The third element is that the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article is capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation and even though harmless under normal use may be found by you to be a dangerous instrument if, under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person, 2, the defendant did cause physical injury to Faison Teal, and 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm.